Okay, so let's start. First of all, hello to all of you. It's very nice to see you, all of you. Thank you for your kind attendance here. As you all know, but otherwise, those who are new here, for them, I would like to introduce myself in a smaller way. Myself, Advocate Preeti Prakash Patwa. I'm from Karanji, and I used to run the law coaching classes for LLB students and CA students. Friends, actually, I'm physically disabled and wheelchair bound, and I always had a complaint with the God that, in spite of the knowledge I have and the skill I have, I can't reach up to the larger students. In spite of the knowledge of the social media option, I never had a thought in the mind to come like this because I had always a phobia or a fear about this. So I never thought about that. But now I thought this is a perfect time in which my knowledge can be useful for someone. So I decided to conduct this lecture for my students. And sharing knowledge in this particular time, I think, will be a perfect one, and this will give the moral satisfaction to the me also and usefulness to the student also. So I am going for this particular lecture. Friends, I think most of the U students are last year students as far as I'm looking right now, and some students are there actually who are even last year completed students are also there. But as I'm looking, most of the students are last year students. Now, see, friends, you are going to put an entry into the new world, which is now the most challenging time of your life. Huh? While dealing with the situation, I remember one quotation I have heard in the speech of former Chief Justice of India, T.S. Thakur, and that particular statement he used in the Nalsar University's last year student program, and that quotation was, "आजादी की रूह जब बेदार होती है नौजवानों में, तो नजर आती है उनको अपनी मंजिल आसमानों में." Friends, this means when youth get to know that they are now going to be liberated, they are going to be freed, they start to find out their destination, that is their manzil, in the open sky, that is Khula Asman. When yesterday I was thinking how to start your lecture, exactly these lines I remember, friends, because now you are also going to be liberated from your limited, restricted life, and exactly this is the time to you to choose your destination of the life, because a life without destination is a very bad way, and so you have to make a choice perfectly right now that what you want to do, and various choices you have after your law graduation. One of the choice you may choose is a widely expanding field nowadays is a practicing in intellectual property rights. Therefore, I thought that why not this subject, and so I have decided to take the lecture for you all on this particular subject, that is intellectual property rights is the topic we are going to deal. See, friends, today's day will be a very introductory part of the intellectual property. Any common man may be attending this particular lecture, even he can understand what is intellectual property. So therefore, without going into the legal aspect, very general basic information about intellectual property we will deal today. That is, as per Shivaji University syllabus, the first part, that is intellectual property, meaning, definition, nature, scope, and Indian regime of the intellectual property. These aspects we are going to cover up today, friends. Now, while dealing with this all issues, intellectual property, the very first question which come in your mind is that one, what is mean by this word intellectual property? See, friends, what we can do is that we can bifurcate this word. We can bifurcate this word. How we can bifurcate this word? Intellectual plus property plus right. This means that a property which is created with your intellect, with your knowledge, that can be considered as a what we can consider as an intellectual property, a property which you have created with your knowledge, with your own intellect, that will be considered as a intellectual property. Consider किया जाएगा यहाँ पे इसको. See, we will take out one example for this one. You all know the famous painter M.F. Hussain. You all know the famous painter M.F. Hussain. Now, this particular famous painter M.F. Hussain has portrayed the image, picture of Madhuri Dixit. That also you maybe all know, huh? Now, that picture of Madhuri Dixit, which is portrayed by M.F. Hussain, is created out of his skill, out of his art, out of his intellect. So, that portrait will be considered as his intellectual property, huh? And now Mr. M.F. Hussain have the right of exclusive use over that property. वो छोड़ के उस property को और कोई use नहीं कर सकता. He have exclusive right to use that property, and commercially exploit it. Commercially exploited stands for commercially none another can take a benefit of that property other than Mr. M.F. Hussain. See friends, this means that these rights of M.F. Hussain, that is exclusive right to use that portrait, then the right not allow anybody to copy it, right to commercially exploit it, that means to take the economic benefits out of that portrait. These all rights are given to the M.F. Hussain only, and that rights are considered as his intellectual property right. Back again, see friends, intellectual plus property plus right, that means a property which is created from human intellect, and which gives certain right to that particular person. This concept will be considered as a intellectual property right concept. Now, see friends, I thought that before going to deal in detail about the intellectual property, what we have to do is that one. First of all, we have to go into the concept of property, because intellectual property will be the next aspect. But before that, we have to go a smaller look on the intellectual property, because almost you all know what is meant by the property. You already studied in detail the Transfer of Property Act, but still we'll have a small look on what is meant by the word property. See, as per the Shastra, there are four aims of human life. As per the Shastra, there are four aims of human life, and that four aims of human life are Artha, Karma, Dharma, Moksha. That means the very first aim of human life, what it is a earth. Earth stand for earning money. See, for living a material life, money is very important, and every human being work for earning money. However, we say that money is not important for us, but we can't ignore the importance of money. See, even in this situation right now, when our life are in danger because of this coronavirus, still we have to start our economic and commercial activities, because we have to boost our economy. And therefore, friends, money is very important. Earth is very important. So every month try to earn the money, then accumulate that particular money. Once the livelihood needs of a man finishes, then man starts to collect the property from that particular money. So we can say that creation, enjoyment, and accumulation of the property is the central activity of the human life. Creation and enjoyment and collection, accumulation of the property is the central point of a human life. Now, what this word property stands for, I remember one definition of the Halsbury's Law of England here. In his definition, he says that property is that which belongs to a person exclusively of other. Property is that which belongs to the person exclusively of others, and it can be subject of bargain and sell. And it can be subject of bargain and sell. That means we will take out one example and we'll deal with this particular definition. Suppose, see friends, I have 100 rupees 100 share of Reliance. Now these shares which I have of 100 rupees 100 shares of Reliance is my property, right? Is my normal property. Now this belongs to me. Okay. So Halsbury says that property is that which belongs to the person. Okay. None other can interfere in my right of enjoyment of this particular property. कोई अदर आके मेरे इस राइट में एंजॉयमेंट में डिस्टर्बेंस नहीं कर सकता है. इसका मतलब मेरे ये जो प्रॉपर्टी राइट है वो कैसा बोलो, एक्सक्लूसिव ऑफ अदर. आई कैन एक्सक्लूड अदर. आई कैन बी द ओनली वन पर्सन who have the right over this particular property. So what Halsbury says that, Halsbury says property is that which belongs to a person exclusively of other, and can be subject to the bargain and sell. These shares are mine. Okay, I can sell it I can gift somebody it, I can do anything what I want to do with that particular property. Okay, so simply considering, what we can say that property means bundle of rights over that particular property. What we can say is that property means bundle of rights. That means I can use that property, I can enjoy that property, I can sell that property, I can give that property. Means a bundle of right over that particular property comes within this particular point. Now friends, see what is the next point is that one. There is another definition of the property, and that another definition is given in the Benami Transaction Act 1988, and in that act it is stated property means a property of any kind. This is a very wider definition of the property, covering many aspects. What this definition is saying that property means a property of any kind, whether movable or immovable, tangible or intangible, and include any right or interest over this particular property. Means this definition is saying is that movable property is a property, immobile property is a property, tangible property is a property, intangible property is a property. Now we are not here going to deal with the other kinds of the property. The only one type we want to deal here is a tangible property and intangible property. Remember what it means by tangible property and intangible property. You must have last year studied in the jurisprudence and transfer of property what is meant by tangible and intangible property. I will explain you still within a 2 minutes. Tangible property is a one which can be seen, which can be touched, which can be felt. Just as for example, take out your car, your mobile, your computer. All these goes into the category of the tangible property. And opposite side, a property which cannot be felt, which cannot be seen, which cannot be touched, is considered as a intangible property. That these intellectual property goes into the category of a intangible property. So got the point? What is meant by the word property? Exclusive right over a particular product, in which you have the right to enjoy it, right to bargain on it, or if you want, you can sell to that property. That is, you are basically considered as a property. And one of the expanding field of the property, which is the topic of our webinar today, and that is intellectual property. So the next step we are going to deal here is what is mean by the intellectual property is the next step we are going to deal. See friends, intellectual property means the property which is created with the intellect. आपल्या बुद्धीतून ज्या प्रॉपर्टीचा जन्म झालेला आहे त्या प्रॉपर्टीला आपण काय म्हणतो तर इंटेलेक्च्युअल प्रॉपर्टी असं कन्सिडर करतो. जसं डिफरंट इन्व्हेन्शन्स येतील त्याच्यामध्ये वेगवेगळ्या प्रकारचे शोध. There may be a different books, there may be a different paintings, songs, symbols, design, image, trademark, which are used in the business. Even copyright on the books, novels, drama, all these will come into the category of the intellectual property. See, you all are aware about the fact the basic difference between human being and animal is that God has gifted the human being with the gift of intellect. And with this particular intellectual capabilities, man can product the new things, man can produce the new things, and this new things, this property which is created from the human intellect. See friends, keep attention on my word human intellect. These properties are considered as an intellectual property. See why I have stress on this word human intellect. I will give you one interesting example here, which is an international case relating to the intellectual property. You can check out on the Wikipedia also. You can easily get this particular case. This case is a case of chimpanzee selfie copyright case. This case is a chimpanzee selfie copyright case. What happened in this particular case, see friends? One British photographer, David Slater, he traveled to the national park in Indonesia for the purpose of taking the pictures of the wildlife. Now, Mr. Slater wanted some unique pictures. So he tried to go to the close to the monkeys and try to take their photos. But as monkeys are shy, he was not able to take that photos. So he used a trick. What he has done, he keep his mobile on a selfie mode and keep the mobile in front of one chimpanzee. Now, as they are a gadget attracted, so that chimpanzee become attracted to the mobile, and he put his leg on that particular mobile screen, and his selfie was taken. The first selfie actually came blur, but he again put that particular mobile in front of the chimpanzee, keeping his selfie mode on, and again that chimpanzee put his leg on the mobile, and one of the unique picture on which the monkey's self-awareness and the monkey's face joy was captured, and that image become very unique image. Now see what happened. He sent this particular image to some of his friends and news related areas. This particular photo was first published in the Daily Mail, and then it became viral. Some days or some years after, this dispute started between this particular photographer's letter and Wikipedia. Actually, this picture of the monkey, that is chimpanzee, was put into the Wikipedia, and he wanted Wikipedia to put down that particular photograph from Wikipedia. But Wikipedia denied, and therefore the matter goes into the court of law. The slatter wanted a copyright over that particular photo. Slatter wanted a copyright over that particular photo, but court denied to give him the copyright, saying that no copyright can be, basically saying that that photo was not taken by the slatter, so it's not created out of the human intellect, and so he is not going to get the copyright over that. So it remain on the Wikipedia, and the matter continues. In the meantime, one of the campaign group, PETA, that is People for Ethical Treatment of Animal, sued Mr. Slatter in a California court on behalf of monkey, and asking the copyright to the monkey, because their argument was that this monkey has taken the selfie. The name of that monkey in that was Naruto. So they were of the opinion that this monkey should be given the copyright over this particular photograph, but the court denied to give the copyright to the monkey, saying that the authorship of intellectual property can be given to the human being, and that cannot be given to the animal. That means ultimately we come to the point from this case also, is that what is mean by the word intellectual property. Intellectual property is the property which is created out of the human intellect. Human intellect मधून मानवी बुद्धीतून ज्या प्रॉपर्टीची निर्मिती झालेली आहे त्याला आपण काय कन्सिडर करणार सांगा? इंटेलेक्चुअल प्रॉपर्टी असं आपण कन्सिडर करणार. Have you heard about World Intellectual Property Organization, WIPO? This is one of the very important organization which is working for the protection of the intellectual property rights. Even Article 2 of the WIPO Convention also defines this word intellectual property, in which it is given that intellectual property include the right related to the literary work, artistic work, scientific work, inventions, scientific discoveries, industrial design, trademark, service mark, and commercial name and designations. This all come within the scope of the intellectual property rights. Now, to understand you, we will have an example on that particular point. See, what this definition is saying is that intellectual property includes the right related to the literary. We can take out an example. Have you heard about the Harry Potter? After writing this particular book, the author of this book has earned crores of rupees out of her intellectual property. That is Harry Potter book. They become the movies also. So literary work can be of intellectual property. Then another example we can take, artistic and scientific work, invention in the field of the human endeavor. You all are aware about the fact of telephone, which is invented by the Graham Bell. This is a invention made by the Graham Bell. So this is also an intellectual property of him. Then we can take out an example of the industrial design. You all may have seen that Coca-Cola tin. The Coca-Cola tin is created or invented by the company, and that company is getting almost 6 crore rupees daily for that particular only tin design of the Coca-Cola. Then see friends, trademark is another type of intellectual property which we have. In the trademark, you can take out an example. Cadbury, Reebok, McDonald's, these all are considered to be the registered trademark. Then service mark is there, Indian Airlines. Then you can take out an example of the United Airlines. These all are considered as a service mark. Again, see, commercial name and designations can also become the commercial name and designations. They also can become the intellectual property. Here we can take out an example of the all you know the famous cricketer Sachin Tendulkar. Now Sachin Tendulkar has registered his name initials as a trademark. Okay, SRT, Sachin Ramesh Tendulkar. This is registered trademark. So if anyone want to use this name SRT, he has to take the permission of the Sachin Tendulkar. He has to pay the royalty to Sachin Tendulkar before using that particular trademark. So in all, these all things come within the definition of the intellectual property. Now see friends, we have seen what is meant by intellectual property. We have seen what is meant by the property. Now, as already I have told you, the next concept, because our paper name is a intellectual property rights is the name of our paper. So the next concept which comes here is the meaning of intellectual property rights. As already I have told you, intellectual property right is a kind of a right that protect the person's artistic work. If I have created certain artistic work, that artistic work will be protected by intellectual property. Some literary work can be protected, just like I have written a drama, book, novel, etc., poem, that can be protected under intellectual property. If I have made any invention, that can be protected under intellectual property. If I have created any design, we used to see that nowadays product's appearance is very important. How a product appear to the eyes is a very important. So everybody is working to give the new design, new type of a look to the product. Okay, so design also become the type of a intellectual property. This means that intellectual property right means the right which can be enjoyed by the owner of that property. उस property के owner उस intellectual property को use कर सकते हैं कैसे? Without any disturbance, and even they can prevent the other from using them without their permission. But see friends, what they can do is that one intellectual property चा जो owner आहे तो त्या property चा एकटा वापर करू शकतो. त्याला वाटलं तर तो दुसऱ्याला अधिकार असाइन करू शकतो ती प्रॉपर्टी वापरण्याचा. त्या पर्टिक्युलर प्रॉपर्टीचं रिप्रोडक्शन, यूज, सेल, कॉपीज करण्याचा अधिकार फक्त त्या पर्टिक्युलर व्यक्तीलाच काय असेल तर अवेलेबल असेल तिथं. सो राईट टू यूज, राईट टू सेल, राईट टू एक्सक्लुसिव्ह यूज, राईट टू मेक द कॉपीज फ्रॉम that particular intellectual property. These all rights are given to the owner of the intellectual property, and that rights are considered as IPR, intellectual property rights. See friends, last year human rights you have studied, and human rights you all may have studied Universal Declaration of Human Rights. This is considered to be the Magna Carta of the human rights worldwide. One of the very important document from the angle of protecting the human rights. Article 27 of the UDHR says that the right to benefit from the protection of moral and material interests resulting from authorship of scientific, literary or artistic production. तुम्ही कुठलेही सायंटिफिक, लिटररी, आर्टिस्टिक प्रोडक्शन केलेलं असेल आणि त्याचे तुम्ही ऑथर असाल, मालक असाल, तर त्यातून बेनिफिट घ्यायचा अधिकार फक्त तुम्हालाच आहे असं कशामध्ये दिलेलं तर आर्टिकल 27 ऑफ द युनिव्हर्सल डिक्लेरेशन ऑफ ह्युमन राईट्स मध्ये सांगितलेलं आहे. सो इन ऑल, intellectual property right is a very important concept. Now you may have a question in your mind, what is the origin of intellectual property right? From where this concept comes, or what is exactly the time when this concept is being originated? When I was reading on the origin of intellectual property right, I found that it is very difficult to find out the origin of intellectual property right, because as man becomes civilized, जशी जशी माणसाची ग्रोथ होत गेली तसं तसं बौद्धिक संपदा म्हणजेच इंटेलेक्च्युअल प्रॉपर्टी राईटची पण ग्रोथ होत गेलेली आहे. त्यामुळे त्याचं एक पर्टिक्युलर ओरिजिन फाइंड आउट करणं पॉसिबल नाही आहे इंटेलेक्च्युअल प्रॉपर्टी राईट्सचा. But still, some of the interesting fact while finding out the origin of this term intellectual property I found was that, see, in Greece before Christ period, 500 BC period in Greece, there was one area known as a Siberius. In Greece, before Christ period 500, there was one area known as a Siberius, and in that area, maybe it is put out in one book that some foodie people were residing in that particular area. And in that area, there was one system, a chef who invented new recipe. जो कोणी शेफ एखादी नवीन रेसिपी इन्व्हेंट करेल, वेगळी रेसिपी असेल, तर त्याला 2 वर्षासाठी त्या रेसिपीवरती मोनोपली दिली जायची. ही वॉज गिवन अ मोनोपली ओवर दॅट पर्टिक्युलर रेसिपी फॉर 2 years, and after that it will be released for the other people. That means for that 2 years only that chef was allowed to do that particular recipe. Then if we come forward, another example I found in one book, that was in the 15th century there was a famous architect. The name of that architect was Filippo Brunelleschi in Italy, and in the state of Florence, all the famous crafts which are created by this Filippo Brunelleschi, and he was given the ownership right also by their government for creations he made. See friends, then again the first patent act which is created, that was also created in the Italy state of Venice, and it is surprising but still important to note that the all important provision today we found in the patent act was also there in the patent act which was created in the Italy in the 15th century. And then slowly this particular concept of intellectual property right started to grow. So here we found the origin of the intellectual property. Okay, so after dealing with the concept of property, concept of intellectual property, then concept of intellectual property rights, and just now we have seen the origin of the intellectual property. Now, as per your syllabus, the next term we are going to see is a basic concepts in the intellectual property. The next term which is given in your syllabus is the basic terms in the intellectual property. See, what are the basic terms in the intellectual property? Very simple part is there. Suppose you are making invention of any patent. If you are making invention of any patent, the basic concept says that patent should be having novelty and inventive step. One which is already produced, one which is already known to the all people, and you are just making the combination of the two things and you are creating something new, then that can be considered as an invention. जे ऑलरेडी सगळ्यांना माहित आहे, ह्याचं त्यात आणि त्याचे हात करून काहीतरी थोडस तुम्ही नवीन शोधला तर त्याला इन्व्हेन्शन म्हणता येणार नाही. त्यामुळे पेटंट म्हणून जर तुमच्या पेटंटला रजिस्टर करून घ्यायचं असेल तर बेसिक कन्सेप्ट काय सांगते सांगा पेटंटची. पेटंट कसं असायला पाहिजे, नॉवेल, अँड पेटंट मस्ट इन्क्लूड द इन्व्हेंटिव्ह स्टेप. काहीतरी नवीन पाहिजे, काहीतरी नवीन शोध असायला पाहिजे, तरच तुमचं पेटंट काय होईल सांगा तर रजिस्टर होईल तिथे. Then next one point about the intellectual properties basic concept is that design law. Now here what it is stated that design must be original which is not previously published in India or in any other country. So basic concept about the design law काय आहे सांगा. डिझाईन कशी पाहिजे, ओरिजिनल पाहिजे. डिझाईन कशी पाहिजे, जी पूर्वी कुठेही पब्लिश झालेली नाहीये अशी असायला पाहिजे. Because if already you can simply take out an example, many types of clothes, or the designs of suit or designs of salwar, sarees, etc. They come in the market, they be there for 2 or 3 months, and they go from the market. Okay, so nobody want to deal with the outdated things. Okay, so if you want to get registered your design under Design Act, what the basic concept is that डिझाईन कशी असायला पाहिजे, ओरिजिनल असायला पाहिजे आणि ती पूर्वी कुठेही पब्लिश झालेली असायला नाही पाहिजे, तरच डिझाईन ऍक्ट खाली तुम्हाला डिझाईनचं रजिस्ट्रेशन करून मिळेल. देन नेक्स्ट पॉइंट वी आर गोइंग टू डील इज अबाउट द ट्रेडमार्क. Now, if you want to make the registration of your trademark, what the basic concept required in the trademark is that trademark must have distinctiveness, and it should not be similar. The basic concept for the trademark used are ट्रेडमार्क कसा पाहिजे सांगा, डिस्टिंक्टिव्हनेस पाहिजे, काहीतरी वेगळं असायला पाहिजे त्याच्यामध्ये, आणि पूर्वी रजिस्टर झालेल्या ट्रेडमार्क सारखा सिमिलर तो असता कामा नये. Trademark law is based on the concept of, what are the basic concept of trademark? See friends, distinctiveness and not similar. So we can take out an example. Suppose Nirma washing powder is one of the famous trademark you all know. And suppose this happened that somebody add 2A to the Nirma, and it is said Nirma. Then I want to get registered trademark. Whether he will get that trademark registered, the law says no, he will not get that trademark registered. Why that trademark will not be registered? The simple reason is that there is nothing distinctiveness, there is nothing new in that particular trademark, and in fact it is similar to the previously registered trademark, so it will not be registered. And the last concept which is required in the basic concept is that about copyright. If you want to get the copyright of any book, novel, drama, poem, literary work, dramatic work, cinematograph, your work should be original. Very important thing. The basic concept for registering the copyright is how your copyright should be, how your work should be. Your work should be original. If your work is original, only then you are going to get the registration of that particular work. Already famous poets are there, and you take the poets different poem and combine the word and want to get it registered. Whether you will get it registered? The answer is no. You are not going to get the registration from that, because they are not original. So if you want to get registered copyright, your copyright work should be original. So that was a point from your syllabus. That was basic concepts of the intellectual property rights. Point wise basic concepts are given. Okay, that we are seeing. Patent, how it should be novel and inventive. Design, how it should be original and not previously published. Trademark, how it should be. Trademark should be distinctive and not similar. Copyright, how it should be original. Then only you will get the registration of your intellectual property rights. Then see friends, the next point which we are going to deal here is that one. The next point we are going to deal is that one, that nature of the intellectual property right. Nature of the intellectual property right. The very first point which we are going to deal in the nature is a territorial nature. First point we are going to deal, which is very important, and that is territorial nature. Now you may ask what it is territorial nature. See, suppose I have invented something in India and I am getting registered it under the Indian law, then I am going to get the protection only in India. Okay, there is no such a thing that a वर्ल्ड पेटंट म्हणजे एकदा आपण रजिस्टर केलं आणि सगळ्या जगामध्ये आपल्याला त्याचं रजिस्ट्रेशन मिळालं, असं वर्ल्ड पेटंट किंवा वर्ल्ड कॉपीराइट अशी काही कन्सेप्ट नाही आहे. त्यामुळे जर तुम्ही इंडियामध्ये तुमचं पेटंट किंवा कॉपीराइट रजिस्टर केलेलं आहे तर तुम्हाला त्याचं प्रोटेक्शन फक्त कुठे मिळेल सांगा, तर इंडियामध्येच त्याचं प्रोटेक्शन मिळेल. मग तुम्ही विचाराल की समजा मला वर्ल्ड वाईड प्रोटेक्शन पाहिजे असेल तर काय करायचं असेल. जसं जसं आपले लेक्चर्स पुढे जातील तसं तसं डिटेल मध्ये मी पुढच्या चॅप्टर मध्ये पेटंटच्या वाला सांगेल. बट स्टील नाव राईट नाव just to give you a simple idea, there is one provision under PCT. Under PCT, Patent Cooperation Treaty, one provision is there. We can make an application under PCT to the 12 countries at a time. एका वेळेला 12 देशामध्ये आपण ऍप्लिकेशन करू शकतो. पण त्या 12 देशांनी आपल्याला रजिस्ट्रेशन मंजूर करायला पाहिजे, तर त्या 12 देशांच्यात आपलं पेटंट काय होते तर प्रोटेक्ट होते. क्वाईट पॉसिबल असे होईल की 12चे 12 देश देणार नाहीत आपल्याला रजिस्ट्रेशन. 10 देशात मिळेल, 8 देशात मिळेल, 2 देशात मिळेल, वॉट एव्हर इट मे बी. बट देर इज अ प्रोव्हिजन अंडर PCT that in India itself, in Kolkata or Mumbai, there are certain offices of PCT. There you can go and you can apply to the 12 countries at a time for registration of your patent, etc. So the very first point in the nature of the patent, you got the point. In the nature of patent, the first point which is put out is its nature is a territorial. That means the country in which you have got it registered, you will get the protection in that country only. Then the second point which come in the nature of the intellectual property is that intangible right over the tangible property. The second point in the nature is a intangible right over the tangible property. I'll give a simple idea about this particular point to you. See, suppose a particular concept come in my mind. I thought that now this coronavirus situation is there, and I have to write down one very important book on this particular situation. And I shared this idea with my one friend. I didn't put that idea on the paper. I just shared this idea with my friend, and my friend made the theft of this idea, and she started to write the book on this particular issue which I shared with her. And then I'm filing the suit against her, saying that she has made violated of my copyright. The question mark is that, can I do this? The answer is no, I can't. See, friends, about intellectual property, you have to keep in mind, until and unless your intellectual property is being put down on certain tangible object. जोपर्यंत तुम्ही तुमच्या कल्पनांना एखाद्या वस्तूवरती अंमलात आणत नाही ना, तोपर्यंत तुम्हाला कुठल्याही प्रकारचे इंटेलेक्च्युअल प्रॉपर्टी प्रोटेक्शन मिळणार नाही. म्हणजेच इंटेलेक्च्युअल प्रॉपर्टी प्रोटेक्शन आयडियासाठी नाहीये. जोपर्यंत ती आयडिया तुम्ही पेपरवर उतरवा, तुम्ही त्या वस्तूवर उतरवा, वॉट एव्हर इट मे बी, somewhere on certain tangible object you have to put it down, then only you can get the protection of intellectual property. Till then you can't get the protection of intellectual property. So the point was in the nature. Got the point? What was the nature? The nature मध्ये आपण हा पॉइंट बघितला काय, intangible right over the tangible property. When you put down it into certain tangible property, then only you can get the protection of intellectual property. Here also we can get one famous case law which is of here also we can get one famous case law of G. Anand versus Deluxe Film and others. In this case, what happens, see friends, appellant R.G. Anand narrated one story about Hum Hindustani to the respondent of this particular case, but nothing else was done by him. And in the meantime, the respondent started to produce the film on this particular topic, Hum Hindustani, and thereafter appellant R.G. Anand filed the suit against Deluxe Film and other, that is respondent, for the purpose of violation of the copyright. But Honorable Supreme Court in this case said, which I have told you, that copyright is not there on the idea or theme, etc. You will get the copyright only when you put it on certain tangible object. जब आप उसको किसी tangible object पे उतारोगे तभी आपको क्या मिलेगा, copyright मिलेगा. तब तक आपको copyright नहीं मिलेगा. So second point about the nature of the intellectual property, you understand, that is you have to put it on certain tangible object. Now, third point about the nature of intellectual property is a right to sue. This already you are aware about the fact. Intellectual property is our asset. We are a owner of that particular property. We have the right to take action, legal action on that person, anybody who has without your permission making unauthorized use of your intellectual property. So simple point is the right to sue. Then next one point which is coming in the nature of intellectual property is that rights and duties. Now see, as you are aware, in law, when we get the rights, we must have certain duties also. Okay, so same with the intellectual property is also there. If you are being a owner of intellectual property, getting certain rights, then you are also supposed to follow certain duties, and one of the very important duty is a public policy, morality. While creating your intellectual property, you should not violate this particular rules. Then next one point which is there in the intellectual property's nature, that is coexistence of different right. The point is a coexistence of different right. म्हणजे काय असेल बघा, डिफरंट टाइप ऑफ IPR कॅन कोएक्झिस्ट इन वन प्रोडक्ट. कधी कधी असं असू शकतं की एकाच प्रोडक्ट मध्ये एका वेळेला एकापेक्षा जास्त इंटेलेक्च्युअल राईट प्रोटेक्टेड असतील. म्हणजे से फॉर एक्झाम्पल बघा, आता कोको कोला कोको कोलाला ट्रेडमार्क पण आहे, कोको कोला हा रजिस्टर्ड आहे. त्याच्यानंतर कोको कोला बनवण्याची जी प्रोसेस आहे ते ट्रेड सिक्रेट म्हणतात त्याला. तर कोको कोला बनवण्याची प्रोसेस ट्रेड सिक्रेट म्हणून रजिस्टर्ड आहे. आणि कोको कोलाचा तो 3 पिन टीन जो आहे तो डिझाईन ऍक्ट खाली पण रजिस्टर्ड आहे. म्हणजे ऍट अ टाइम एक इन्व्हेन्शन किंवा एक प्रोडक्ट वरती एकापेक्षा जास्त इंटेलेक्च्युअल राईट प्रोटेक्शन पण असू शकतात. सो इन्व्हेन्शन मे बी पेटेंटेड ऍट द सेम टाइम अँड ऍट द सेम टाइम it may be protected under the copyright, it may be protected under the Design Act also. So friends, these are all points, and in which the last one, in the nature of intellectual property is dynamism. Dynamism means changing, continuous development. You are very well aware about the fact that intellectual property is nowadays expanding field. Day by day, new things are getting added into the part of the intellectual property, because intellectual property is reaching into the all areas of the human activities, and therefore new type of intellectual properties nowadays are creating is a bio patent. Then plant diversity protections. These new types of intellectual properties are also getting developed nowadays. So friends, in the nature of intellectual property, the points which we have seen, you see, number 1 point we have discussed that intellectual property is a territorial in nature. Number 2 point we have discussed is that intangible right over the tangible property. Number 3 point we have discussed that intellectual property gives the owner right to sue. Then number 4 point we have discussed that intellectual property gives you rights also and it gives you duties also. Number 5 point we have discussed is that in intellectual property at the same time there may be a coexistence of different rights. एकाच वेळेला अनेक राइट्स त्याच्यामध्ये एक्झिस्टेड असू शकतात. And the last point in the nature of intellectual property we have discussed that dynamism, that is changing process, continuous development process. So this is how you can explain the nature of intellectual property as per your syllabus. And now the last part we are going to deal is the Indian regime for the intellectual property. Indian regime for the intellectual property is the last part we are going to deal now. Now, see friends, India has ratified the convention of the WIPO, and that convention of the WIPO which India has ratified is the TRIPS. Tomorrow we are going to deal with the international aspect of the intellectual property. So our first chapter will be covered there. So one of the point tomorrow in detail we are going to discuss is the TRIPS, and this TRIPS agreement, trade related intellectual property right agreement, which is an agreement made by the WTO, World Trade Organization. India has ratified this particular agreement in the year 1994, and therefore accordingly India has made many amendments in our intellectual property right laws. In India, basically the various intellectual property rights are there. Out of that, the very first intellectual property right, which will be our second chapter, is a copyright. We'll just today have a look over it in a 2-3 lines, and then every day one chapter we will cover up, in which one point we will cover up everything about copyright, everything about trademark, everything about patent. One by one we will go into covering this all issues. But today, as per your chapter number 4 syllabus, the last point is the last point which is put out is the Indian regime of intellectual property right. And as I already told you that intellectual property protection was there in India even before TRIPS agreement also. But India signed the TRIPS agreement in 1994, and thereafter India has made various amendments in the Indian intellectual property law to cover up or to adjust with the TRIPS agreement. So first intellectual property right which we found in India is a copyright. Okay, now you are already aware about this fact. Copyright protect the original work, as I already told you. First of all, keep in mind, if you are copying somebody else, then you are not going to get the protection of the copyright. दुसऱ्याचं काहीतरी चोरून तुम्ही तुमच्या नावावर छापायचा प्रयत्न करत असला तर त्याचं कॉपीराइट तुम्हाला मिळणार नाहीये. त्यामुळे तुम्हाला कॉपीराइट कसं पाहिजे सांगा, तुमचं वर्क हे ओरिजिनल असायला पाहिजे. देन नंबर 2, कॉपीराइट तुम्हाला कशासाठी मिळेल बघा, यू मे गेट द कॉपीराइट फॉर लिटररी वर्क, म्हणजे साहित्य, ज्यात ड्रामा असेल, नॉवेल असेल, पोएम असेल. Then you may get the copyright for the music. Now in the music composer also get the copyright, and the person who sing that particular song, that is singer, also get the copyright over his singing. Then even dramatic work, cinematographic work, then graphic work, sound recording, artistic work, architectural work. And another important point is the software also. मेनी स्टुडंट थिंक दॅट सॉफ्टवेअरला पेटंट मिळत आहे, पण सॉफ्टवेअरला पेटंट नाही मिळत. सॉफ्टवेअरला काय मिळते तर सॉफ्टवेअर इज गोइंग टू गेट द कॉपीराइट. ओके, सो ऑन ऑल दिस पर्टिक्युलर इश्यूज यू आर गोइंग टू गेट द कॉपीराइट इन इंडिया. इंडियामध्ये कॉपीराइट प्रोटेक्शन साठी एक लॉ पास केलेला आहे, अँड द नेम ऑफ दॅट पर्टिक्युलर लॉ इन इंडिया फॉर द कॉपीराइट इज अ Copyright Act 1957 is the law. As I already told you, to keep with the changing pace, several times this law has been amended. बऱ्याचदा हा लॉ काय केलेला तर अमेंड केलेला आहे. बाकी डिटेल्स कॉपीराइटच्या चॅप्टर मध्ये आपण डिस्कस करूच, पण एक सिंपल पॉइंट इथे सांगून थांबवते कॉपीराइटला. कॉपीराइट जो आहे ना तो बेसिकली जनरली इफ यू आर टॉकिंग अबाउट द ऑथर ऑफ बुक एक्सेट्रा, देन त्याची पूर्ण लाईफ त्या बुक वरती त्याचं कॉपीराइट असते. ही गेट द कॉपीराइट ओव्हर दॅट पर्टिक्युलर बुक फॉर हिज एंटायर लाईफ अँड ॲज वेल ॲज देअर आफ्टर 60 years. How much year he is going to get the copyright on the book? Entire life of the author plus 60 years will be the period for which he is going to get the copyright on that particular work, whatever he has done. Okay, so copyright is one of the very important aspects in which, as I already told you, book, music, film, television, computer, database industry, all these are covered under the copyright. One of the famous case actually on this particular issue of the copyright, which also I will share with you. YRF, that is Yashraj film versus श्री साई गणेश प्रोडक्शन नाम की केस हम लोग यहाँ पे क्या करेंगे, डील करेंगे. काय झालेलं होगा ह्या केस मध्ये कॉपीराइट इन्फ्रिंजमेंट सूट यशराज फिल्म प्रोडक्शननी फाईल केलेली होती. कुणावर फाईल केलेली तर श्री साई गणेश प्रोडक्शन्स अँड अदर यांच्यावरती फिल्म सूट फाईल केलेली. कशासाठी सूट फाईल केलेली बघा. दिस सूट वॉज फाईल्ड बाय द यशराज फिल्म ऑन साई गणेश प्रोडक्शन अँड अदर फॉर violation of the copyright of the movie Band Baja Barati. And their view was that the film which is produced by Shri Sai Ganesh Production named Zabardast, that movie is a copy of this particular film Band Baja Barati. Their argument was the film's concept, theme, plot, character, sketch, story, everything is copied from our film. And the Supreme Court gave the judgment in the favor of a Yashraj Film Private Limited and granted the injunction, saying that you are not allowed to make the copy of this particular film's theme, story, etc. So the first part in India in the protection of the intellectual property is the copyright. Okay, and the law in India for the protection of the copyright in detail will deal in the chapter. That law is the Copyright Act, is the law which is there. Then next second point which come in the Indian regime of the intellectual property right is a trademark. The second point which come is a trademark. See now what this word trademark stands for. Trademark is a type of a symbol which distinguish the product of the two people. सिम्बॉल मुळे हा काय होईल सांगा, दोन लोकांचे प्रोडक्ट डिस्टिंग्विश होतील. तुम्हाला तो सिम्बॉल बघितला की लगेच कळेल की हा प्रोडक्ट वेगळा आणि तो प्रोडक्ट काय तर वेगळा आहे तिथं. सो ट्रेडमार्क इज अ वर्ड असू शकतो, एखादा शब्द असू शकतो. जसा फोर्ड आहे, फोर्ड हा एक शब्द आहे, तर तो शब्द ट्रेडमार्क बनला. ट्रेडमार्क एखादा सिम्बॉल असू शकतो किंवा ट्रेडमार्क एखादी डिझाईन असू शकते. पण दोन प्रोडक्टना एकमेकांपासून वेगळं करणारा जो मार्क असतो त्याला आपण काय कन्सिडर करतो सांगा तर ट्रेडमार्क. इव्हन एखादा लोगो ट्रेडमार्क असू शकतो, एखादं प्रोडक्ट ट्रेडमार्क असू शकते, एखादं पॅकिंग स्टाईल ट्रेडमार्क असू शकते. सो देर मे बी अ डिफरंट टाइप ऑफ अ ट्रेडमार्क विच आर रजिस्टर्ड. Have you seen the two word on the particular product? Sometime there may be a word TM or there may be a sometime word R on the trademark. TM stands for ट्रेडमार्कच्या रजिस्ट्रेशन साठी ऍप्लिकेशन केलेलं आहे. TM स्टँड्स फॉर ट्रेडमार्कच्या रजिस्ट्रेशन साठी ऍप्लिकेशन केलेलं आहे, पण ऍप्लिकेशन अजून मंजूर झालेलं नाहीये. आणि जर आर सिम्बॉल असेल तिथं तर आर म्हणजे ते ट्रेडमार्क काय असेल सांगा तर रजिस्टर्ड ट्रेडमार्क असेल ते. So another important part of the Indian trademark regime काय सांगितलं तुम्हाला, trademark is a type of a symbol, logo, slogan, or it may be a word. I've told you many trademark. Okay, Cadbury is one of the trademark. Then Reebok is another type of a trademark. The Star Plus color combination is also considered to be their trademark. So there may be a different variety of the trademark. Here even I would like to share one interesting fact. In England, a smell can be considered as a trademark. इंग्लंडमध्ये स्मेलला पण ट्रेडमार्क म्हणून काय केलं जातं तर रजिस्टर्ड केलं जात आहे. तर त्यांच्याकडे तो टेनिस बॉल असतो ना विम्बल्डनला, तर त्याला फ्रेश ग्रासचं स्मेल असतंय आणि ते सुद्धा ट्रेडमार्क म्हणून काय केलं जाऊ शकतं तर रजिस्टर केलं जाऊ शकतं. पण आपल्याकडे काही स्मेल नाहीये. आपल्याकडे ट्रेडमार्क कुठल्या फॉर्म मध्ये रजिस्टर्ड असू शकते तर सिम्बॉल, वर्ड, लोगो, स्लोगन, डिझाईन, this form may be the in the form of a trademark. Now for trademark also I would like to share one famous case law with you, and that famous case law of the trademark is the Yahoo versus Akash Arora and another case is there. Yahoo versus Akash Arora and another. In this case, what happens? See, you all are aware about the Yahoo domain, which was very famous at one time as a searching site. Or like Gmail account, Yahoo account was also there. Now what happened in this case? The plaintiff's Yahoo domain was there, and defendant created Yahoo India domain. So plaintiff filed a suit against the defendant Aksharo Ran and other for the violation of his trademark. Court also held that these all are used on the social media. They looks like similar, Yahoo, Yahoo India. Even they are phonetically also similar, Yahoo, Yahoo India. In both the word Yahoo is there, so they are phonetically also similar. So therefore court allowed the injunction and prohibited the defendant from using this particular symbol of the Yahoo India here. So the next point we will deal here about the intellectual property right in India. That next point we are going to deal. Before that, as I already told you, in India for the protection of the trademark there is a one law, that is Trademark Act we are also having of 1999 in India for the protection of the trademark. Trademark Act 1999. Then the next type of intellectual property we are going to have in India is a patent. Now patent, what it is? Patent is a type of a invention. एखाद्या गोष्टीमधला नवीन शोध म्हणजे काय कन्सिडर केलं जातं सांगा? पेटंट कन्सिडर केलं जातं. पेटंट मुळे नवीन नवीन शोध जे आहेत त्यांना मोटिवेशन मिळतं, कारण आपण केलेलं पेटंट आपल्या नावावर रजिस्टर होणार आहे, त्याचं जे मॉनिटरी बेनिफिट आहे ते आपल्याला मिळणार आहे. त्याच्यामुळे पेटंटला काय तर खूप व्हॅल्यू आहे. आजकाल पेटंटचा स्कोप खूप जास्त वाढत चाललेला आहे. पेटंट ऍक्ट खाली काय सांगितलेलं बघा की पेटंट कशाला मिळेल? इन्व्हेन्शनला पेटंट मिळेल. तुम्ही जे काही नवीन कराल त्याच्यासाठी तुम्हाला पेटंट मिळेल. आणि इन्व्हेन्शन जे आहे ते इन्व्हेन्शन कशासाठी असू शकते सांगा? आर्ट, प्रोसेस, मेथड, मॅन्युफॅक्चरिंग, मशीनच्या बाबतीत, अदर आर्टिकल्सच्या बाबतीत इन्व्हेन्शन केलं जाऊ शकतं. सो इन ऑल व्हॉट दे वॉन्ट टू टेल इज दॅट पेटंट कॅन बी ऑन द प्रोडक्ट अँड प्रोसेस ऑल्सो. गेटिंग व्हॉट आय एम टेलिंग यू? पेटंट कशावर दिलं जाऊ शकते? प्रोडक्ट वरती पण दिलं जाऊ शकतं आणि पेटंट प्रोसेस वरती पण दिलं जाऊ शकतं. प्रोडक्ट वरती म्हणजे एखाद्या वस्तूवरती आणि त्या वस्तूला बनवण्याच्या पद्धतीवरती पण पेटंट काय केलं जाऊ शकतं ते दिलं जाऊ शकतं. यू कॅन टेक आउट एन एक्झाम्पल. सी, कॅशू बिस्किट्स आर देअर. काजूचे बिस्किट असतात. काय सगळ्या काजू बिस्किटची चव सारखी असते का? बघा, इव्हन गुड डेच्या बिस्किट पेक्षा कितीतरी चांगल्या क्वालिटीचे कॅशू बिस्किट्स आपल्याला मिळतील. पण जी टेस्ट गुड डेला आहे ती सिमिलर टेस्ट तुम्हाला दुसऱ्या प्रोडक्ट मध्ये मिळेल काय? तर नाही मिळणार. का? कारण त्यांची बनवण्याची पद्धत सुद्धा पेटंटेड असते. सो पेटंट हे कशाला दिले जाऊ शकते सांगा? तर पेटंट हे प्रोडक्टला पण दिले जाऊ शकते आणि पेटंट हे प्रोसेसला पण दिलं जाऊ शकते तिथे. Then next point which we are going to deal here is we will deal with one of the smaller case law also to make you known about this particular concept patent furthermore. A famous case which recently happened at a international issue. The name of this particular case is Coca-Cola versus Bisleri International Private Limited. The name of case is Coca-Cola versus Bisleri International Private Limited. See what happened in this particular case. Bisleri International, who is best known, you are aware, for the bottled water. Now it sold the trademark Maaza to the Coca-Cola, and including the right to formulate intellectual property right and goodwill attached to the mark for India to the Coca-Cola. Now in 2008, what happened? Defendant make an application in Turkey for the purpose of registration of trademark Maza. Maza trademark they sold to the plaintiff, and then thereafter they are filing the application in Turkey country for the purpose of registration of same trademark Maza. But here the court gave a decision in favor of the Coca-Cola, and granted the injunction, and stopped the defendant from using that particular trademark under the ground of passing of an infringement of trademark. ग्राउंड वरती कुणाच्या फेवर मध्ये डिसिजन दिलेलं होतं, तर कोका कोलाच्या फेवर मध्ये ते डिसिजन दिलेलं, कारण त्यांनी तो ट्रेडमार्क माझा काय केलेलं होतं तर विकलेला होता तिथं. Now the next step of intellectual property which we are going to have in India after the patent we have seen, the next step is a design. Now see, the next step what I have told you, it is a design. Generally it is said that design can be felt only by the eyes. We can't understand the design by our hand or smell, etc. So design is something which can be judged only by the eyes. Only by the eyes we can judge the design. For protection of design in India, previously there was a Design Act 1911 which is replaced by the Design Act 2000, and under this particular Design Act 2000, now the law is made according to the TRIPS agreement. ट्रिप्स अग्रीमेंटला धरून चेंजेस काय केलेले आहेत तर डिझाईन मध्ये केलेले आहेत तिथं. डिझाईन आजकाल बिझनेसचा काय सांगा तर एक इंटेग्रल पार्ट आहे. डिझाईन खूप इम्पॉर्टंट कन्सिडर केली जाते. कारण एक चांगली डिझाईन असेल तरच कस्टमर काय करतील तर त्या प्रोडक्टला परचेस करायचा विचार करत असतात तिथं. इव्हन डिझाईन कशाची असू शकते सांगा, क्लोथ्सची डिझाईन असू शकते, ऑर्नामेंट्सची डिझाईन रजिस्टर केली जाऊ शकते. कॅन इट बी पॉसिबल टू रजिस्टर द डिझाईन ऑफ एनी व्हेकल? येस. इवन व्हेकल्स डिझाईन कॅन बी रजिस्टर्ड. से फॉर एक्झाम्पल यामा गाडीची डिझाईन आहे ती रजिस्टर्ड आहे under the Design Act. Nobody else can use without the permission of the company. So the point has been that one. What the point? One of the important aspect of the intellectual property right in India is the design. Because as I already told you, a thing of beauty is a joy of forever. एखादी गोष्ट सुंदर असेल ना तर ती बघायला छान वाटत असतं आपल्याला. त्यामुळेच प्रत्येक वस्तूला आजकाल मार्केटमध्ये चांगलं छान दिसायला चांगलं बनवण्याचा प्रयत्न केला जातो, आणि त्याला त्या बनवणाऱ्याच्या नावानं प्रोटेक्ट करण्यासाठी म्हणून कुठला लॉ बनवलेला तर डिझाईन ऍक्ट काय केलेला तर क्रिएट केलेला. मग डिझाईन ऍक्ट खालची एखादी फेमस केस लॉ आपण बघू शकतो का तर येस. Ampro food product versus Ashoka biscuit work is the case. Ampro food product versus Ashoka biscuit work. What happened in this particular case is that this appellant and respondent both were the manufacturer of biscuit. Appellant's design was already registered, and respondent biscuit are having the identical design as of appellant. जशी appellantची डिझाईन होती ना तशी डिझाईन कुणी बनवली तर रिस्पॉन्डंटने बनवली. फक्त फरक काय केला त्यांना की रिस्पॉन्डंटने आपल्या डिझाईन वरती A-B लेटर लिहिला आणि त्या आधीचं अपेलंटचं लेटर काय होते तर A-P होते. मग त्यामुळे अर्थातच सूट फाईल झाली. इथं कोर्ट हेल्ड दॅट देर इज अ व्हायोलेशन ऑफ द रजिस्टर्ड डिझाईन अँड कोर्ट इश्यूड द इंजंक्शन restraining the respondent from using the appellant's registered design of the biscuit. So in all, design act खाली तुमची डिझाईन जी तुम्ही बनवलेली आहे ती काय होईल सांगा तर प्रोटेक्ट होऊ शकते. ओके, सो डिझाईन, copyright, patent, these all are considered to be the intellectual properties in India. Trademark, and the last one, intellectual property, which is actually not in our syllabus, but nowadays that is considered as a very important intellectual property in the market, and that is geographic indication. Have you heard about this one, geographic indication? Sometime geographic indication, have you heard? No. See, I will explain you what is meant by geographic indication. When a particular product is identified with the geography and get registered, it becomes the geographic indication. That product may be manufactured product or that may be naturally produced in that particular area. Simplest example of the geographic indication we can take out is the Kolhapuri chappal. This is a geographic indication, a chappal which have distinct design, distinct style, and which is manufactured only in the Kolhapur, is considered as a geographic indication in a Kolhapur area, which is registered nationally, internationally. Another example you can take out is the Nagpuri Santra, that is naturally produced product, that is also considered as a geographic indication. And for the protection of geographic indication also, we have the law of 1999 on the prohibition of the use of geographic indication unauthorizedly. So see friends, this all come within the domain of the intellectual property regime in India. So here half chapter of your first topic we are finishing: nature, scope, meaning, basic concepts, then Indian regime for intellectual property, right? These all issues, half chapter we have completed here. Tomorrow we'll deal with the international aspect of the intellectual property, right? That is, we will deal with the WIPO, World Intellectual Property Organization, World Trade Organization, TRIPS Agreement, TRIMS Agreement, UNESCO, and their role in the intellectual property. Okay, thank you. What I will do is that I will read your comments, and if you have any doubts or if you have anything else from your comments, you can mention me so that I can make further improvement or give you further knowledge. Yes, somebody told that Devgad Hapus, it is also a type of intellectual property in the form of a geographic indication. Many are there. Kanchipuram sari is there, Darjeeling tea is there. Further, we can go in detail in the different chapters. You will get the detailed information also. Okay. Hope I was able to satisfy you. We will meet tomorrow. I will see your all comments in the comment box, and I will try to give the answers to your queries also if there are any queries. Okay. Thank you.